This is an appeal in the matter of Jones and Wrexham County Borough and others.
Yes, Mr Wilkinson.
My Lord, I appear for the appellant together with Mr McKay. A learned friend, Mr Carter, appears for the first respondent, Local Planning Authority. Mr Corner KC appears for the second respondent, the Welsh Ministers. And Miss Ellis KC appears for the third to sixth respondents together with Mr Millet.
Thank you. And we have been told that, is this right, that others are arriving in due course this morning?
My Lord, yes, there's a minibus of councillors who have come from Wrexham.
Yes.
We've tried to leave enough seats so that there won't be any disruption, and if there aren't enough seats, they've been told to wait outside until there are. Yeah. So hopefully there will be no disruption to the court.
Is it councillors or
Council.
council? You said, I think...
Councillors.
Councillors?
Yeah, no, a minibus of council would probably be too many, but no, it's councillors.
Yes, well, as all of you will be aware, and I ought to make this clear, there was discussion as to appropriate venue, and all parties were given the opportunity to contend for a hearing in Wales in the event. Nobody contended for that, and hence we took the decision, given the court's resources and pressures on the court, that on this occasion we would hear the appeal here in London.
My Lord, that's absolutely right. If I could just deal, first of all, just a couple of housekeeping matters. In terms of bundles, there's a core bundle, supplementary bundle, and an authorities bundle.
Yeah.
In terms of the authorities bundle, there are two additional provisions that the parties would like to hand up.
Yes.
The first is we thought it would be useful for the court to have section 23 of the 2004 Act as originally enacted for the changes to the Localism Act.
Thank you. Yes.
And then the second provision is one which the respondents may refer to, which is section 122 as originally enacted.
Have you handed these?
No. My Lord, I have copies of section 122. I think my learned friend has copies of section 23. So if Your Worship wouldn't mind...
Right.
Oh, thank you very much.
Thank you. Thank you very much. Where do you want us to put these?
So, my Lord, in terms of section 23, I'd suggest tab 8 of the authorities bundle, and then put it behind section 23 as it currently is. So it would become page 30A.
30A.
And then in terms of section 122, it's tab 29 of the authorities bundle.
We've on this side got 4 copies of section 122.
Yeah, I see what's happened. I've got 3 of section 23. I think they've been handed up
So I want one of those.
as a clip.
Number 22. 122.
Alright, so 30A and then 122 is what number, please?
So that's tab 29,
Yeah.
and then that would become page 79A.
Thank you. 79A and 79B.
79B, yeah.
Thank you.
Thank you.
Right, so that's all the paper.
That's all the paper and housekeeping.
And you can take it that we have read the papers with a focus, of course, on the most salient materials. You can assume that for the purposes of making your submissions to us. We've been assisted, of course, also by skeleton arguments from all counsel, and we have digested those as well. And just taking a view of time, without in any way seeking to compress submissions, does, I think, occur to me, if not also to my colleagues, that given that we are focusing on matters of construction here, if that's to say statutory interpretation, we may finish the appeal in the day. I know it's been given a day and a half.
Yeah.
Perhaps a little on the generous side.
Perhaps, yes. I hope to be up to lunch and no more. So that may mean that we can
obviously we don't want arguments repeated.
No. No. And my lord, for that reason, I wasn't going to go through the factual background, which is set out in the judgment.
There's no need to do it.
No need.
You can get straight to the meat of the appeal.
Well, look, can I do that then? And as the court's aware, the issue is one of statutory construction, and that's whether Section 67 of the 2004 Act grants a discretion on local planning authorities to decide whether or not to adopt a local development plan, where the inspector examining the plan recommends adoption, or whether once the inspector recommends adoption, with or without modifications, the LPA has no discretion but to adopt the plan in line with those modifications. And the latter, of course, was the interpretation of Mr Justice Eyre, which is under appeal. And what I propose to do is set out what we say are the 5 main or headline reasons why the appellant's interpretation of Section 67 is to be preferred, and then develop those submissions. So the first is the ordinary and natural meaning of the word may, as used in Section 67, is that it gives a decision maker a discretion. Second, given that Section 67 uses discretionary language, for a duty to adopt to exist, there will need to be something in the statutory context that indicates that the legislative intention was to the contrary. Third, whilst the respondents rely on the restrictions on withdrawal in Wales after submission of the plan, the purpose of those restrictions is to enable the government to call in a plan that it thinks is capable of being adopted, and to prevent the LPA effectively removing that power by unilaterally withdrawing the plan.
Yes.
And if that's right, the appellant's interpretation is not incompatible with that purpose.
And the provisions you've got in mind there are specifically which provisions?
66A. Well, 66A 4 is the one that governs the position post-submission, but we say that that's the purpose of the whole of Section 66A.
Yes.
And if that's right, then a decision not to adopt a plan is not incompatible with that purpose, because a non-adopted plan can still be called in. Which is also the answer to the limbo argument that non-adoption creates a limbo. It doesn't. The government considers that it's a plan that's capable of being adopted, it can call it in.
Yes.
The next point we say is that there are in fact clear contextual indicators supporting an interpretation that may here does indeed mean may. And in particular, if it was intended that there be no discretion as to whether to adopt a plan, Parliament would not have chosen a procedure to mark the adoption of a plan that is a clear and public demonstration of a discretion being exercised, i.e. the passing of a resolution by voting on a motion. It's fundamentally inconsistent with there being a mandatory duty to adopt. And then finally, on the respondent's notice point, which relates to Regulation 25, of the 2005 regulations, we say that ultimately that regulation is of little assistance because correctly interpreted, it's simply dealing with the timescales in which a decision on adoption must be made. It doesn't create a mandatory duty to adopt where none existed in the parent legislation. So, my Lord, I was going to then develop those points, but also, towards the end, deal with the position in England, because we say that's also highly relevant context, because it's not in dispute, as we understand it, that there's a discretion not to adopt following receipt of the inspector's report in England. And given that, it's instructive to look at the language of the English provisions and the Welsh, and language and structure of the English provisions and the Welsh provisions to understand why that may or may not be the case. One would expect to see a clear difference. We say the position in England and Wales has always been, since adoption, enactment of the 2004 Act, that there's a discretion in both England and Wales. So if I can then start off with section 67 itself, that's at tab 23.
Yes.
Page 63 of the authorities bundle. And subsection 1 and 2 deal with two potential scenarios. The first, where the inspector carrying out the examination of the plan has recommended that the plan as originally prepared is adopted. And then the second, where the inspector carrying out the examination has recommended that the plan is adopted with modifications. And in both subsections, the language that's used is may adopt. And the ordinary and natural meaning of the word may is that it gives the decision maker a discretion. And we rely there on what was said by Lord Justice Mummery in the Families Need Fathers case. But also it follows as a matter of language. May means may doesn't mean must. My Lords, for your note, I don't think we need to go to it, but the relevant bit in the Families Need Fathers case is it's at tab 38, page 136 of the bundle, paragraph 23.
It's really a conditional power, isn't it, on one reading, because it says you may adopt a local plan as originally prepared if. So what it's making clear, maybe going further, but what it's making clear is you can't modify the plan if the inspector has recommended that you adopt the original plan.
Yeah. And once modifications are proposed to the plan, you have a choice. You either adopt with those modifications or you don't adopt. There's no third way of adopting, as my Lord says, with different modifications, which is the position in England as well. And that ordinary and natural meaning is reinforced by the remainder of the section, because if we look at subsection 4, the authority must not adopt a local development plan if the Assembly directs them not to do so. So the section itself uses mandatory language where it was intended to remove any discretion on the part of the LPA. And if subsections 1 and 2 were intended to create mandatory obligations, it's surprising that the similar language was not used there. So we say on the basis of that the starting point is a presumption that section 67 is conferring a discretion on the LPA. Now that's a presumption that can of course be displaced. That requires something in the context which indicates clearly that the legislative intention was to the contrary. And we can see that from the summary of the position in Benyon, which we have at tab 50 of the authorities bundle.
Yes.
And it's page 383.
Yes.
Now this is in the context of enabling power. The same approach should be taken in a more general context. And it's under the heading permissive or mandatory words. The starting point is that the use of the word may or other permissive language confers a power, whilst the use of must or other mandatory language imposes a duty. And then at the bottom of the page, starting point, so whether it's a starting point or a presumption, starting point is that the use of the word may will usually be construed as conferring a discretionary power in the absence of something about the legislative context that leads to the conclusion that the intention was to the contrary. So that's what the respondents need to show, something which in the context demonstrates a contrary intention. And putting it another way, since there's no express duty to adopt in section 67, that obligation would need to be implied into the section. And that was the approach taken by Mr Justice Eyre. We can see that from paragraph 48 of the judgment below, so it's in the core bundle at page 217.
Thank you.
And it's so paragraph 48, page 217, and 4 lines up from the bottom, Mr Justice Eyre says, when seen in context, the effect, and that's the effect of the language used, is that it is a necessary implication into section 67 that the authority must adopt the plan in one or other of the ways set out there, those ways being governed by the particular circumstances of whether there has or has not been a recommendation for modification to the plan. Now, I'll come back to that, whether there's any significance of the fact that there's 2 potential routes to adoption later. But in terms of approach, the approach taken by Mr Justice Eyre is that by way of necessary implication, an express duty can be implied into the Act. And that's important because for an implication to be necessary, it must be compellingly clear, having regard both to the words used in the Act and their context. So compellingly clear, and authority for that is the DPP case, which you'll have seen referred to throughout my skeleton, which is in the authorities bundle at tab 44. And it's page 258. Now,
In the sideline passage.
in the sideline passage, now the context here was very different. It was whether the common law presumption that there's a mens rea element to offences was rebutted by the Act. But in terms of what's needed, what quality of indication is needed for a necessary implication, I do rely on what Lady Arden said at paragraph 34. At the last 3 lines, necessary implication is an implication that is compellingly clear. Whether that is so turns on the words used in the light-of-day context and the purpose or mischief of the provision in question. So what we're looking for, given we have discretionary language as a starting point, is something in the context which makes it compellingly clear that actually there is an implied duty to adopt in section 67. And my lords, I'd just ask you to bear that in mind as we go through all of this, because there may well be indications that do support the respondent's case to some degree. The question is, though, whether at the end of all of this exercise of statutory construction, we've reached a position where the court's satisfied that it's compellingly clear that may in section 67 in fact means must. So what I'm going to do in terms of structuring my submissions is first go through the indications that the respondents rely on, and then pick up on indications which we say actually support the ordinary and natural meaning of the words used in section 67. So if I can start off with the withdrawal provisions, and the respondents say that a power not to adopt the plan would undermine the restrictions in the Welsh legislation on the LPA's power to withdraw a LDP once submitted for examination. And it's also said, linked to that, that it would create a limbo where the authority has voted not to adopt the plan, but does not itself have the power to actually withdraw the plan. So the starting point to respond to that argument is section 66, which is tab 21, page 60 of the authorities bundle. And this section, which I'll come back to in a minute because it's part of the answer we say to the limbo point, but it gives a power on the Welsh ministers to direct withdrawal of an LDP at any time prior to adoption. We then go ahead to section 66A, which deals with withdrawal where there is no such direction. And this imposes restrictions on the ability of a local planning authority to unilaterally withdraw its plan. So we start off with subsection 2. Subject to the provisions of this section, the authority may withdraw the plan at any time before adopting it under section 67. And then there are three main restrictions on withdrawal that are set out in section 66A. So the first, we can see from 66A subsection 3, that's where the Welsh ministers have exercised their intervention powers under section 65 or 71. The second, subsection 4, is where the plan has been submitted for examination. And in those circumstances, withdrawal can only take place where that's the recommendation of the inspector examining the plan, and that hasn't been overruled. And then third, there's a restriction on withdrawal prior to examination unless notice has been given to the Welsh ministers. And that was a change that was introduced, it was added into part 6 by the Planning Wales Act 2015. So clearly, whereas here a plan's been submitted for examination, an LPA cannot unilaterally withdraw its plan. The question is that clear and compelling evidence of a intention behind section 67, which is different to the ordinary meaning of the words used? And the starting point to answer that is that there's a clear conceptual difference between not adopting a plan and withdrawing a plan. And the difference between withdrawal and non-adoption is that when a plan is withdrawn, it ceases to exist as a document. And we can see that from Regulation 26 of the 2005 regulations, which is at tab 32 of the authorities bundle.
Yes.
So Regulation 26, as soon as reasonably practical after an LDP is withdrawn, the LPA must do various things, publish a notification, tell those who were previously consulted. But D is important. Remove any copies, documents, matters and statements made available or published under Regulations 15, 17 and 19. So all published copies of the plan and supporting documents are removed. The effect of that is that the Welsh Government loses its powers to intervene by calling in the plan under section 65 of the Act. A withdrawn plan cannot be called in under section 65. If we go to section 65...
Does it also follow on your submission section 71, default power would not be available either?
That's right.
Sorry.
Yeah, I'll come to section 71. I mean, we don't demur from what's said by the respondents that in a situation like this, Section 65 is the more obvious intervention power. But yeah, the same argument would apply to Section 71. So Section 65 can be seen at it's tab 19. And it's Section 65(4). At any time before a local development plan is adopted by a local planning authority, the Assembly may direct that the plan is submitted to it for its approval. And just for shorthand, I'm calling that call-in power.
Yeah.
Following that intervention, the Welsh ministers may then subsequently approve the plan under Section 65(9)(a), which is over the page. Now, since a plan that's withdrawn ceases to exist, the effect is that Welsh ministers cannot call in the plan and then subsequently approve it if they wish to under Section 65(9)(a). And we say that is the purpose behind the restrictions on withdrawal in Section 66(a)(4) is to prevent plans which may be capable of being adopted or approved being withdrawn by LPAs, with the effect that the government loses this power under Section 65(4) to call the plan in. In other words, the legislature did not want LPAs to have unrestrained, unrestricted ability to withdraw a plan once it was submitted for examination, because that would effectively usurp the call-in powers of the government. And some support for that interpretation can be seen by looking at the reasons why the amendments were made to Section 66(a) by the Planning Wales Act. My Lords, if you recall, subsection 5 of 66(a), which deals with the situation prior to submission of examination, was added in by the Planning Wales Act.
Sorry, which provision again?
So it's Section 66(a),
Yeah.
subsection 5 to 9. And it's the provisions that deal with the situation prior to examination where notice has to be given to the Welsh ministers before the plan is withdrawn. And we can see the purpose behind that provision from the explanatory memorandum, which is at tab 49. Page 380. My Lords, I'm going to ask you to read paragraphs 3.46. It's the sideline passages. The reference to the IAG is it's the Independent Advisory Group, which was set up to review the delivery of the planning system in Wales. So that's the reference to the IAG. Well, also, if I could just ask you to read the sideline passages.
So that's 346
and
347.
347. Yeah.
Yes.
So, my Lord, I'd suggest that...
Sorry to interrupt, but
No.
could I just be clear about what was inserted by the 2015 Act? Subsection 5? Because you made your submission a moment ago by reference to subsections 5 to 9, but what was in section 65 before this amendment?
This... My Lord, if you go to tab 20, This is the position on enactment of the 2004 Act. So there was a restriction that's originally enacted on withdrawal after the plan has been submitted for independent examination, unless the inspector recommends the plan be withdrawn or it's directed that the plan must be withdrawn. Section 66, as originally enacted, was then replaced by two sections through the Plan of Wales Act, 66 and 66A. Subsection 4 of 66A matches up the original provision in the 2004 Act, so the language used in section 66 as originally enacted.
Well, 66A4 is the equivalent of 66 as originally.
As originally enacted,
Thank you.
yeah. And then what we see in 5 to 9 are new provisions which weren't in the 2004 Act as enacted. I think the way I described it was, my language was probably too loose.
Forgive me, I follow what you say because we have at tab 36, section 13 of the 2015 Act, which says that section 66 of the 2004 Act originally enacted was replaced by the new section 66 and 66A.
Yeah.
But I think it would be helpful, just to be absolutely clear about this, to have section 65 before it was amended, because some of those provisions must have been in the original section 65. For example, in subsection 9, the power to approve. Because
Section 60.
what seems to be added seems to be in subsection 5
Yeah.
and subsection 6.
Yeah.
But when you read on 7 to 9, it looks as if that was in the original section 65.
Yeah,
Well, I'm
but-
not sure that section, if Milan Friend will forgive me, I'm not sure that section 65 has been amended.
Ah,
Are we at cross purposes?
No, no,
Sorry.
that's right.
I see what you mean. Yes, I'm with you. Yes, sorry.
Yeah, so section 65 is unchanged, so
Yes.
the intervention powers are unchanged.
Yeah, sorry, it was my fault.
No, my lord. So that's why I said what's new effectively is subsection 5 to 9 in 66A. But just going back to the explanatory memorandum
Yes.
and the reasons why those provisions were introduced, I would submit that very strong support of what we say is the purpose behind section 66 as a whole. In particular, what's said at the end, throughout, but in particular what's said at the end of paragraph 3.46 and over the page, which is that withdrawal of a plan means that the Welsh ministers can't progress the LDP to adoption if it's considered appropriate to do so. And the key sentence is the first of paragraph 3.47. To ensure that LDPs which are potentially capable of adoption are not withdrawn for non-planning reasons, there's a requirement to notify the Welsh ministers of any resolution to withdraw. And we say that that is also the purpose behind section 66A 4. And once that's understood, a decision not to adopt does not cause harm to the purpose behind the restrictions in section 66A4. And that's because where a plan isn't adopted, the government still retains its powers of intervention under section 65 or 71. And just to see that again, we can see that section 65, which is tab 19, page 57, section 65.4 applies at any time before a local development plan is adopted by a local planning authority. The Welsh ministers may direct the plan submitted to them for approval. So if the LPA chooses not to adopt a plan at the end of the process, a direction can be made by the Welsh ministers under section 65, effectively calling it in. So therefore, a decision not to adopt doesn't frustrate the statutory purpose behind section 66A4. And nor does it frustrate one of the purposes of the Act, which is to ensure that LPAs have up-to-date LDPs. That purpose can still be achieved even where an LPA chooses to adopt a plan. That's because if the government wants to ensure that it has an up-to-date plan and it thinks there's a sound plan or a plan that's capable of being adopted has been rejected for non-planning or non-good reasons, it can intervene under Section 65.
So therefore, the fear that the plans will be just left in limbo is addressed.
My Lord, absolutely. So it's addressed through Section 65 if the government thinks that a wrong decision has been made, but also it's addressed through Section 66. Because on the other hand, if Welsh ministers think, actually, we're happy with this decision, we've got no issue with it, they can make a direction under Section 66 that the plan's withdrawn. So where a plan isn't adopted, the ball's put in the government effectively. It has two choices. If it doesn't want to interfere with the LPA's decision, it can make a withdrawal direction under Section 66. On the other hand, if they're not happy with the decision made by the LPA, they can intervene under Section 65(4). So, to the extent that a limbo is created, it's created by the Welsh Government not exercising the powers it has to make a final decision on what should happen to a plan that's been rejected at a local level.
If the Welsh ministers do call in a plan under Section 65(4), going to subsection 9, it seems to give the ministers three options. They can approve subject to modifications, or reject.
Yeah.
So does it follow that they're not bound by the recommendations of the inspector?
Yeah. And one of the points I'm going to come to later is looking at the language of Section 65(9), but then 71. If we just go to it now, Section 71 on tab 24, page 64, says the Assembly may approve the plan as a local development plan, following receipt of the recommendations by the inspectors. Now, may in that context, so this is where the default power has been used under Section 71. There's a report from the inspectors, and then 71(4) says the Welsh ministers may approve the plan as a local development plan. Now, may in that context must include a decision to not follow the recommendations of the inspectors. Otherwise, you'd have less power under your default power than you did under Section 65. So may in that context must include a rejection of the plan. And it would be very odd if that language in Section 71(4), which is similar to that used in Section 67, had a different meaning. So, my Lord, yes, I do rely on that point. But just going back to the limbo point, if there is a limbo, it's because the government hasn't used powers that it has at its availability to break the limbo and make a decision one way or the other. But also, there's nothing inherently difficult with the concept of a non-adopted but non-withdrawn plan. Because that is the same situation that you have under Section 65(9), for example, where the Welsh ministers called in a plan and they decided to reject it. It's then not adopted, but not withdrawn. It's also the situation that arises in England, and I'll come back to this later, where, as is not disputed, there is a discretion not to adopt, and no obligation on the government to call in a plan in those circumstances. You have non-adopted and non-withdrawn plans. There's nothing to stop the local planning authority starting the plan-making process, having not adopted but not withdrawn a previous plan. So we say that actually, if there is a limbo, it's not a problematic limbo. It's not a limbo at all. It's just a situation where you have a non-adopted, non-withdrawn plan. But to the extent that that situation is problematic, the Act gives powers to the government to deal with the problem, to make a decision one way or the other.
It's subject, of course, to the general requirement to prepare a plan in section 62.
Yeah.
That pervades the whole exercise that you've been describing, I think.
Yes, and we don't dispute that one of the purposes of the Act is to ensure that local authorities adopt up-to-date plans. That's the same in England and Wales. But it is also one of the purposes of the Act to ensure that local authorities are satisfied with the plan that they have at the end of the process. Because otherwise you have a situation, as here, where there's a challenge to the plan supported by the leader of the council, whose council has adopted a plan that the leader of the council doesn't want to see. So yeah, we fully accept that that is one of the purposes of the Act, but that purpose can be achieved whilst also having discretion about the plan that you have at the end of the process. And in any event, just going back to clear and compelling evidence, this would be a very odd and circuitous route to secure mandatory adoption of a plan by reading section 66A(4) together with section 67. It'd be far more obvious to simply use the word must in section 67. So that's the first piece of context. The second is some reliance is placed on the structure of section 67. So going back to that, tab 23, page 63. Oh, sorry, my lord, just before I do that, can I just go back to one point the respondents make about section 65, 5C. And so if we go back to section 65, it's tab 19, and then it's subsection 5C, so page 58. And what's said, so this is dealing with the procedure after the call-in power has been used. What C says is, if the direction is given after the authority has submitted the plan, the person appointed to carry out the examination must make his recommendations to the Welsh ministers. And it's suggested that this indicates that it was anticipated that any direction would be given before the inspector examining the plan makes their recommendations and not after. And there's 3 points we make in response to that. First is suggested it doesn't go that far because Welsh ministers accept that there is a power to call in after the inspectors have published their report. And we can see that, just for your note, it's paragraph 25, second respondent skeleton argument, page 155 of the bundle. But that must be right, and we can see that from elsewhere in the Act. So if we go back to section 66A, 4, so tab 22, page 61, this is dealing 4A says there's circumstances where withdrawal can happen after submission, and 4A says only if the person carrying out the independent examination recommends that the plan is withdrawn, and B, the recommendation is not overruled by a direction given by the Welsh ministers. Now that must be a direction under section 65(4), i.e. one directing that the plan submitted to it for approval, or potentially under section 71. Those are the only 2 powers where such a direction could be given. So the legislation on its face shows that a direction can be made under section 65(4), even after the inspectors have published their report.
Sorry, the 2 provisions were 65?
65(4).
Yeah.
And we then rely on 66A(4)(b) to show that a direction not only can be made after the inspectors have published their report, but it's a scenario contemplated by the Act. So that's the second point. And the third point is...
Sorry, I'm just looking at section 66A 4 again.
Yeah.
Subparagraph A recommends that the plan is withdrawn, and B, the recommendation is not overruled by it. It seems to be talking about direction specifically on that point, and you see it also in the parallel English provision in section 22.
Yeah. But in terms of the power to give that direction, that's either in section 65 or 71, because there's no other power. I would suggest that what that's saying is that the recommendation is not overruled by a direction given by the Welsh ministers, i.e. the Welsh ministers haven't intervened under section 65(4) to call in the plan. I mean, perhaps I don't need to persuade the court of that, because what's not in dispute is that the call-in power still exists after non-adoption.
Well, that's clear from section 65 subsection 4 itself.
Yeah, yeah.
You can't rewrite.
No. But I'm now here dealing with the respondent's point that if you then look at 65(5)(c), that suggests that the Act contemplated or only contemplated call-in happening pre.
I'm sorry, but that would be inconsistent with subsection 4.
My lord, that would be the better argument for me to have made, yeah. And in practical terms, it can just be dealt with by an addendum addressing the same recommendations that have been made to the LPA to the Welsh ministers. So if I can then deal with the other contextual point relies on, which is the structure of section 67 itself.
Yes.
So that's tab 23, page 63. And it's right to say that Mr Justice Eyre did place some reliance on the structure of section 67. And we can see that from it's paragraph 48 of the judgment below. So that's page 217, paragraph 48. And he says it's right to note that section 67 does say that the local authority may adopt a local plan. However, when seen in context, the language of that section and the reference to may adopt is talking about the different ways in which adoption can be effected, or rather about the different forms of plan which can be adopted in different circumstances. So, in other words, it's said that may is used because the LDP can either be adopted in its original form or with modifications. And the simple answer to that is that structure of the section and the two routes to adoption doesn't explain why may has been used, because the section would work just as well if the word must had been used. So it's not a contextual point that really takes us very much further, we would submit. And then there's the overarching point, which I've sort of touched on as we've gone along, which is that the overall purpose is to have up-to-date local plans. Well, yes, but that doesn't give way to the other purpose of the Act, which is to ensure that local authorities ultimately have control over the plan, that whether to adopt or not adopt a plan at the end of the process. And that purpose of ensuring there are up-to-date plans applies just as much in England as in Wales. So it can't explain, I'll come back to this a bit later, it can't explain why the provisions are different in England as opposed to Wales. So those are the main factors relied on by the respondents as showing that the context indicates that may here in fact meant must. And I would submit that whatever the position, that they're not clear and compelling. And in fact, properly construed, there's an explanation for those provisions which is entirely consistent with the discretionary power in section 67. If I can then turn to indications that in fact we say support a permissive interpretation of section 67, and there are three main factors we rely on. The first is the fact that not just within section 67, but throughout Part 6, a distinction is made between mandatory duties and discretionary powers. That's point 1. The second is the point I mentioned earlier, which is looking at the language used in section 67 compared with sections 65 and 71, which deal with the scope of the discretion for the Welsh Government when they intervene and make a decision on whether to approve a plan. And then the third is the fact that the legislature has chosen a resolution procedure before a plan could be adopted. So if I deal with these in turn, and first of all, we say that this distinction between may and must, permissive and mandatory, permissive power and mandatory duty runs throughout the 2004 Act. And I'll just go to a couple of examples. So the first is section 62, so that's tab 16. Page 48. Subsection 1, the local planning authority must prepare a plan for their area to be known as a local development plan. Subsection 3, the plan may also set out specific policies in relation to any part of the area of the authority. So you must prepare a plan, and then you have a discretion as to whether you have specific policies in relation to different parts of the area. And we can also, and have seen that distinction between may and must in section 65, which is tab 19, page 57. Subsection 4, the Welsh ministers may direct that a plan is submitted to it for its approval, so it's a discretionary power. But where such a direction is made, we look at subsection 2, the authority must comply with the direction. So reading this in context, may and must are being used in familiar ways to mark a distinction between discretionary power and a mandatory duty. So that's the first point. The second point is that this relationship between section 65, 9, section 71 and section 67. So there are two routes by which an LDP may form part of the development plan, either adoption by the LPA or approval by Welsh ministers. And my Lord, as you noted earlier, if we look at section 65.9 to tab 19, page 58, it is clear that where the call-in procedure has been used, the Welsh ministers are not bound by the recommendation of the inspector. They may reject the plan submitted to them. I do place some reliance on that when we then look at the language used in section 71. So that's tab 24, page 64. Now there is
Can you give the reference again?
sorry, my Lord, it's tab 24,
Thank you.
page 64. Now there is some overlap in the circumstances where section 65 and section 71 can be used. So for example, where an LPA has prepared a plan, but for whatever reason has decided not to submit it for examination, the power in either 65.4 or 71 could be used. But what I place reliance on is what's said in 71.4b. So after an independent examination has been held, after the recommendations have been published, section 71.4 says that the Welsh ministers may approve the plan as a local development plan. Now, may in that context must include a power for Welsh ministers to reject the recommendations of the inspectors. Otherwise, you'd have a bizarre situation where Welsh ministers were more constrained if they'd used their default power under section 71, as opposed to if they'd called it in under section 65(4). And the reason why we say that is important is because if you compare the language of 71(4) with the section we're obviously concerned about, 67, may is used in both. It would be odd if may in section 71(4) conferred a discretion, but may in section 67 conferred a duty. We say the situation is consistent. At the end of the plan making process, across all of these sections, there is a discretion to either adopt or not adopt following receipt of the recommendations of the inspectors. And the legislature would not have used the same language in both section 67 and 71 if one was intended to confer a discretion and one was intended to confer a mandatory duty. And then the final factor that we rely on is the fact that an LDP can only be adopted following a resolution. And we would submit that this is a powerful indicator that there's a discretion as to whether or not to adopt following a recommendation. So the starting point is section 62, so that's tab 16. Page 50, section 62(8). A plan is a local development plan only insofar as it is adopted by resolution of the local planning authority as a local development plan, or is approved by the Assembly under section 65 or 71. And that's then reiterated in section 67 itself, page 63, where subsection 3 says a plan is adopted for the purposes of this section if it's adopted by resolution of the authority. Now, a resolution can only be passed following a vote, and a vote requires a choice. So the 2004 Act requires a process to be followed where members of the local planning authority are given a choice through a vote on whether or not to adopt the plan. However, on the respondent's interpretation, that choice is entirely illusionary, because on its interpretation, that vote can only have one lawful outcome. A vote to adopt is lawful, a vote not to adopt is unlawful.
Is resolution defined in the Act?
My Lord, I'll check. I don't think it is, but I'll check.
So you're asserting that a resolution
can only be passed following a vote and a voice.
a vote implies. Is that just an assertion?
Or
is it an assertion supported by
I hope
definition and statutory authority?
I hope it's an informed insertion on the basis that that's the ordinary and natural meaning of the word. I would double check though whether there's any definition in the Act. I don't think there is. But a resolution normally requires a vote. It requires a choice to be presented and members to vote one way or the other. And certainly where the same language is used in England, that is the process that is adopted at the end. The plan goes to full council normally, given the significance of the decision, and there is a recommendation where there's a positive report, recommendation to adopt, and full council votes on that. They decide whether to either adopt
Because
or
if your proposition is right, it could be said that that would be a clear indication of the conferring of a discretion, as opposed to the imposition of a mandatory duty.
Yeah, and that's why we rely on it and say that it is such a powerful indicator, because it would be a very odd process for Parliament to have chosen if there is no discretion, because the vote could only have one lawful outcome. It also sets up a bizarre situation where you have a meeting, and these decisions are invariably made at full council, given their significance. You have a meeting being held, purportedly to decide whether this plan should be adopted or not. Members of the public can turn up and speak, officers speak, councillors make speeches, a vote is held at the end. But the whole thing is effectively a charade, because there is only one outcome that is lawful. The outcome is preordained.
As against this point, the respondents, I think, rely upon the English provision, section 15, subsection 7 at page 12 of the bundle, which is to do with a local authority adopting a local development scheme. And the word resolution or resolve is used in 15.7.
Yeah.
And they say, well, that's not incompatible. Using the word resolve is not incompatible with the existence of a duty or obligation.
Yeah, but that's because in that scenario, officers at the authority, say, could have prepared a scheme. It then goes to full council, and members would still vote on it in order to decide whether to pass the resolution or not. And they may take the view that actually they weren't satisfied with the recommendation, because in that case would have come from officers.
Just looking at subsection 7 again, it is specifically for the purposes of bringing the scheme into effect.
Mm. Well, it says...
And it says also that the resolution must specify the date in which it has effect. So it may be said perhaps it's focusing on that aspect rather than the content of the scheme and its merits.
Yeah, yeah. But yeah, I submit that the situation is different. But in any event, under subsection 7, you could have, it would and could be lawful for a vote to take place on whether to bring the scheme into effect, and members of the council to decide actually they weren't happy with the proposal. Because for that procedure to work in subsection 7,
in other words, subsection 7 is procedural.
it's procedural, yeah.
Rather than substantive.
Procedural rather than substantive.
If you need a resolution to formalise the end point in the whole process, one can see the sense of that, can one, in the consequences of that adoption, namely that the plan becomes part of the development plan with all the consequences that follow from that. So one could see an argument, could one, that the resolution is the defining act, if you like, that brings that status into effect on that date. Is that right or not?
We would definitely agree to the extent that there needs to be some marking of a plan being adopted for all sorts of reasons, not least you need to know when the 6-week challenge period under section 113 kicks in. So something, we accept there need to be some formal marking. But then Parliament has a choice about how that is marked. And it would be odd to have created or chosen a procedure that involves a vote. One other way of doing it is that, and we would suggest more obvious way of doing it, if there is a mandatory duty, is that once the inspectors have published their report, there is a duty on the LPA to publish a version of the plan with those modifications. That would formally mark the adoption of the plan. That would start the 6-week period running under section 113. And that procedure is used under section 113 for other types of document. So
it's used for the plan for Greater London, isn't it?
Yeah, yeah. And that procedure would be consistent and would actually be a strong indicator of their mandatory duty. But Parliament has chosen a resolution, ordinary meaning, I'll check on the statutory meaning, but ordinary meaning is a resolution requires a vote. And if the respondents are right, it creates confusion. This is the only time in this case where I'll dip into the facts, because it's illustrative of what we say would be an absurd situation. So we can see what happened here. So if we could go to the supplementary bundle. And it's page 228. So this is an email from one of the councillors to the monitoring officer after the order of Mr Justice Eyre. So this is before it comes back to the third and final full council meeting. And the councillor asks a series of questions, so we can see them bullet pointed. 1. Do members still have a right to vote as we choose on this matter, or do we no longer have that right? 2. What are the specific implications, if any, for individual councillors who choose to vote against adopting the plan? And 3 is less relevant, it's about getting specific legal advice. What then comes back, we can see at page 227.
Yeah.
The position remains, as always, at council meetings that councillors are free to vote how they choose. That must be right. However, as you're aware, there are consequences, and those consequences are set out 3 paragraphs down. If councillors choose to vote against adopting the plan again, then the statutory duty will be breached again. The case will return to court, incurring further legal costs. The judge can find the council in contempt of court if it disobeys a court order. As individual councillor votes will be available, presuming there's a recorded vote, then the court can make an order against those individuals. If the court finds the defendant in contempt of court, the court may impose a period of imprisonment, a fine, confiscation of assets, or other punishment permitted by law. So members are being told they can choose how to vote, but unless they vote one particular way, they may go to prison. Now, that advice is given in the context where there is a court order mandating adoption, but if Mr Justice Eyre's interpretation is upheld, any interested party would be able to go to court to get a similar order if councillors chose not to adopt a plan.
Linda Roberts is the council's solicitor.
Solicitor, yeah.
It's monitoring officer.
Monitoring
Monitoring
officer.
officer.
Apologise. Monitoring officer.
We don't quarrel with that interpretation if the judge is right. You might.
No, I don't. Yeah, I mean, may impose a period of imprisonment. Yeah, that there is a risk that individual councillors could face themselves in that situation. But the simple point is, what is set up is, we say, a farcical procedure where you have a meeting of full council, members being asked to vote on a resolution, a debate, but there is only one lawful outcome, and in circumstances where, as here, somebody has gone to court to get a mandatory order, there is a risk of councillors being in contempt of court unless they vote one particular way on that vote, and that cannot have been Parliament's intention when enacting the 2004 Act.
Can I just ask, I hope I'm not steering you off your course.
No.
Just taking a step back.
Yeah.
Am I right that the consequence of the judge's interpretation is to remove an element of democratic control over the process?
Yeah. And I was going to come back to that at the end.
Right.
But
And that is going to be where your peroration.
my period, yes, it's my finale.
That is.
Yeah, but that's absolutely right, and it removes the democratic choice. A development plan is a very significant document for a local authority. It guides development control decisions in their area for 10, 15 years. It cannot be right, just standing back from all of this, the local authorities can be compelled to adopt a plan that they do not wish to adopt, and then to use that plan to guide development decisions in their area. That cannot be.
And your point would be that the statutory scheme provides for their decision to be overridden by the central government, by the Welsh government.
Yeah, I think my fundamental point is that local authorities submit a plan to examination that is examined by inspectors who make a recommendation. And it is then, at the end of the process, up to local authorities to decide whether they follow that recommendation and adopt, or don't and don't adopt. And that causes no difficulty with the overall statutory scheme, because in a situation where local authorities choose not to adopt, the government can, and that still has, to answer my Lord's point, a democratic mandate, because it's a decision made by the government and ultimately
At Welsh national.
at Welsh national
Which can
level.
override,
Yeah,
if Welsh government thinks it's appropriate,
yeah,
the local democratic.
yeah, precisely. But it's democratic throughout.
And the status, forgive me, sorry to interrupt, but just to follow on my Lord's point, the status of the plan, having gone through that avenue of the procedure, in other words, approval by the Welsh ministers, enjoys precisely the same, or it is precisely the same status as if adopted by the local planning authority itself.
Yeah, yeah, and we see that from section 62 at the beginning. Yeah,
Just picking up my Lord Justice Baker's point, perhaps we shouldn't overlook, you touched on section 62 and you looked at subsections 1 and 3 on page 48, but subsection 2 says the plan must set out, B, their general policies. That's not necessarily the final word, because the minister may intervene. But the starting point when the plan is being prepared is it sets out the policies of the local authority.
yeah, yeah,
And this was commented on by the House of Lords in the Westminster case in 1985. It means that if you can't put your policies as a local authority in a non-statutory document,
yeah,
but the statutory document must set out your policies,
yeah.
subject to the checks and balances within the Act.
Yeah, yeah, and those checks and balances ultimately having a democratic mandate behind them, because central government intervening, I should say, still has a democratic mandate at the end of it. But yeah, I would, my Lord, absolutely rely on what's said at 62(2)b. So those are, I'm going to deal with the situation in England and then Regulation 25. But those are within the four corners of Part 6, where we're at. We have a starting point where there's a discretionary power, and we've got various indicators that perhaps support or don't support. But standing back, we say that actually everything in Part 6 reinforces the use of the word may. But even if we're wrong on that, one does not read Part 6 and get to the end of it and think, oh, well, may in section 67, that obviously means must. That obviously imposes a duty. I would submit that we are very far away from that situation. So that's Part 6. I'm then going to deal with the position in England. Because the starting point is it doesn't appear to be in dispute that in England, LPAs have a discretion not to adopt a local development document, even in circumstances where the inspectors examining the document have recommended adoption. And we do say that that is highly important context. We recognise that planning isn't a reserved matter, and in principle there is no reason why the situation may not be different in England and Wales. But when reading the 2004 Act as a whole, the fact that the statutory language used in Part 2 in England leads to a situation where there's a discretion is highly relevant context. Because then it becomes relevant to ask why the structure and language of Part 2 leads to what's accepted to be a discretion, but not in Part 6. And we actually say that when we do this exercise, there are differences between Part 2 and Part 6, but actually the reality is the fundamental structure is the same in Part 2 and Part 6, and that is a further indicator that in Part 6 there is a discretion. So if I could just pick up on some of the features which are relied on by the respondents and show that they're also present in England. So if we could start off with section 19, so that's tab 3 of the authorities bundle. Yes. Page 16, section 19(1). Development plan documents must be prepared in accordance with the local development scheme. So, in England, as in Wales, there's an obligation to prepare development plan document in accordance with a development scheme. So then if we go over the tab to section 20, that development plan document must then be submitted for independent examination. And in England, as in Wales, section 22b, the authority can only do that when they think the document is ready for independent examination. Then there are powers of intervention on the Secretary of State that are similar to those here under section 65(4). So, and in particular, if we go to section 21, section 21(4) and 5, and over the page, matches up with what we saw in section 65(4) in part 6. So the existence of these features alone in the Welsh legislation cannot explain why the respondents say there's no discretion in Wales, because they're features of the English legislation as well. Then what I propose to do, and I hope it would be useful and helpful, is just to go a little bit through the legislative history, starting with the 2004 Act as enacted, and then the changes on both the English and the Welsh side. Right. And that may also help with the interpretation of section 67 as we currently are.
Right.
So we say that when originally enacted, there was a discretion in England to adopt or not adopt, and a discretion in Wales. And nothing has changed from the amendments to the Act that affects that. The respondents accept that the position is now different. However, it's not clear if it's their position that the England and Wales started from divergent positions under the 2004 Act, or whether we are now in a different place because of amendments that have been made to the Act. But the starting point, we say, is that when the 2004 Act was enacted, the provisions on adoption and withdrawal were materially the same in England and Wales. So in England, we go to section 23 as originally enacted. So that's tab 8, page 30A. And we start with section 23(4). The authority must not adopt a development plan document unless they do so in accordance with subsection 2 or 3. So the power in subsections 2 and 3 are the only ways in which a development plan document can be adopted. And if we then look at section 23, 2 and 3 and compare that with what's in section 67, which has never been amended, the language is the same. Then in terms of withdrawal, the position was the same in England and Wales as originally enacted. So that's section 22 in England, which is at tab 6. Page 27. And the same starting point in Wales, which is at tab 20, section 66. So we say the starting point is materially the same in England and Wales. And given that, either there was a discretion on enactment in both England and Wales, or there was a mandatory duty to adopt in both England and Wales. And we say it was the former, and nothing has changed. There were then changes to Part 2 through the Localism Act in England, and changes to Part 6 through the Planning Wales Act. It's not entirely clear what the respondent's position is. Whether they say that what started as a mandatory duty to adopt in both England and Wales changed in England through the Localism Act amendments to create a discretion, or whether they say that what started off as a discretionary power in both England and Wales changed to a mandatory duty to adopt in Wales through the changes through the Planning Wales Act. Given the starting point's the same, it can only be one of those two possibilities, and I'll deal with both sets of changes. So starting with England, the first change made by the Localism Act was to section 23. And we can see that at tab 8. So the basic structure is retained. We can see that from subsection 4. The authority must not adopt a development plan document unless they do so in accordance with subsection 2 or 3. Subsection 2 is dealing with a plan which is recommended to be adopted unchanged. And the wording that we have in the amended wording is very similar to that in the original enacted version, except that there's now an additional, section 2b gives an additional power on local authorities in England to make modifications that, taken together, do not materially affect the policy set out in the plan.
Can I just see if I've understood this?
Yeah.
The amendment introduced by the Localism Act reflects the main modifications procedure.
Yes.
That arises where an inspector concludes that a plan is unsound.
Yep.
The only way then of saving the plan is by the local authority requesting the inspector to make main modifications to make it sound.
Yep.
In Wales, I think there's no statutory requirement for the plan to be sound. It's a policy aspect.
It's a policy, yeah.
But I don't think there's a statutory fetter on adoption. If there is, I've missed it.
No, that's right.
That you can't adopt unless the inspector has found the plan to be sound.
Yeah. Yeah. Yeah.
But your submission is that the structure, the legal structure, is still the same. You have two routes in England.
Yeah.
The second one involving main modifications, which constrain the form in which you can adopt as a local authority.
Yeah. Yeah. If you are to adopt the plan, you have to adopt it as amended or modified.
As recommended by the inspector.
But it doesn't follow from that you lose your choice not to adopt at all. the main difference, I suppose, my Lord, absolutely, it's the main modification procedure and the fact that I suppose additional control is given to local authorities because main modifications can only be made if the local authority asks the inspector to do so at the examination. But
if they don't do that, the plan falls.
The plan falls, yeah. The simple point is none of this suggests that the position on enactment was that there was a mandatory duty to adopt in England and that these changes have created a discretion. The position's the same. Yes, there's slightly more control to local authorities because the plan won't be amended unless they ask the inspector to do so. And my Lord, as you say, if they don't ask the inspector to do so, what will come back is a recommendation for non-adoption. So these changes, we say, in England don't change the starting position. The other change that was made was to the withdrawal provisions in section 22 as originally enacted. And so on enactment, the restrictions on withdrawal were the same as they are now in Wales. That then changed through the Localism Act, and we can see that at tab 7.
Sorry, forgive me, I don't think that's quite right, is it? The restrictions in England originally were the same as originally in Wales, because
my Lord,
the 2015 Act has introduced further restrictions.
Yeah, sorry, that's absolutely right.
Yeah, but I think that's your argument, isn't it?
That's our argument, but my Lord, you're absolutely right. I wasn't precise enough and probably was wrong. Yes, that is the position. Section 22 was then amended through the Localism Act, which is tab 7, page 28. And those restrictions on withdrawal post-submission are removed, and a local planning authority may at any time withdraw the document. And of course, I rely on what I previously said about the purpose of what was originally section 22 and is now in Wales, section 66A. It's there to enable the government to call in a plan that it thinks is capable of being adopted and to prevent the LPA removing that power by withdrawing the plan. So the fact that this restriction was removed through the Localism Act doesn't help us with understanding whether there's a discretion at the end of the process. I would suggest the removal of that restriction through the Localism Act is reflective of an approach which sought to minimise the extent to which central government could intervene in local authority decision making. And that's why that change was made through the Localism Act. But nobody would look at that change and say, oh, well, that has the effect of converting something that was a mandatory duty on enactment into a discretion to adopt post the Localism Act. So the Localism Act obviously gives a degree of more control to local authorities, but doesn't change the fundamental structure of Part 2. And if you're with me on that, that helps cut through in some ways the relevance of the changes to Part 6 in Wales. Because there are two main changes and differences that respondents rely on. The first is that through the Planning Wales Act, there are those additional restrictions on withdrawal pre-submission. And also what is in section 66A4 now, which isn't in England. But the simple point is, in England, when the 2004 Act was originally enacted, section 23, if you're with me that conferred discretion, that discretion is not incompatible with having restriction on withdrawal post-submission, because that was what was in England in section 22 as originally enacted. There's no incompatibility between the two. The second main difference relied on by the respondents is the fact that the National Development Framework for Wales is part of the development plan in Wales and states that LDPs must be kept up to date. But the relevance of this depends on the respondent's starting point, on whether there was a discretion in Wales when the 2004 Act was originally enacted. If it says that there was a mandatory duty in Wales to enact, even on enactment, then the fact that the Planning Wales Act made this document part of the development plan doesn't help us, because it doesn't change the starting position. But if the starting position was that there was a discretion in Wales on enactment of the 2004 Act, the question then becomes whether the fact that NDFW is part of the development plan in Wales, whether that demonstrates that something that was previously in discretion has now become a mandatory duty. And we say that the change clearly isn't sufficient to demonstrate that. For a start, whilst NDFW is part of the development plan in Wales, the MPPF also references throughout the importance of up-to-date plans. And whilst not part of the development plan, LPAs must have regard to it in preparing their plan. And we can see that from section 19.2, so tab 3, page 17.
Sorry, tab.
It's tab 3, my lord, page
Yeah.
17.
Thank you.
In preparing a development plan document, the local planning authority must have regard to national policies and advice contained in guidance issued by the Secretary of State. And also, the MPPF is brought in because the MPPF is what sets out the soundness tests, which are then one of the criteria against which plans are examined. So the MPPF is also brought in England in a similar, albeit different way to the way NDFW is in Wales.
Well, in Wales, I think there's a requirement that the local plan to be in general conformity with the national policy document.
Yeah, yeah. Yes, there is. There is. But the national policy document doesn't tell us anything about whether there's a discretion to adopt or not. It just talks about the importance of up-to-date plans. And for the reasons I've said, there's no incompatibility between that and local authorities having an ultimate decision on whether to adopt a plan or not. So it would be very odd, I would submit, and a very indirect way of doing it, if that requirement for general compatibility between an LDP and the national policy document created a mandatory duty in Wales to adopt where one previously didn't exist. It would not be the procedure that the legislature would have adopted to make that change. It would have simply changed the wording of section 67. All of these points relied on by the respondents are so indirect and we say convoluted that it just simply begs the question, why not just change made to must? Then the final topic I would like to deal with is the explanatory, well, the other material that we have before us, because the respondents also rely on the explanatory memorandum for the 2004 Act. So that's at tab 48 of the authorities bundle. And it's page 353. And reliance, it's the sidelined paragraph. It says, in relation to Wales, planning is an area in respect of which functions are devolved to the National Assembly. The Assembly Government published its own consultation paper, Planning Delivering for Wales, in January 2002. The Act gives effect to the Assembly's Government's policy formulated in the light of responses to the consultation document. So that's where the respondents start, and from there we go to the consultation document, Planning Delivering for Wales, which is at tab 3 of the supplementary bundle. And it is page 271. And reliance is placed, as I understand it, on what's said at paragraph 35. Local planning authorities would be required to publish an adopted version of the plan, incorporating any changes from the scrutiny process within a fixed period. The plan could automatically be adopted after a set period for legal challenge. Now, to put this in context, this is all under the heading procedures, and it's all under the headline proposal. We propose to revise the regulations to require local planning authorities to prepare their plans to an agreed timetable. So these are proposals that are primarily dealing with timetabling, and we can see that because when we go to the response form, I'll come back to paragraph 35 in a minute, but if we go to the response form, which is at page 291, question 8, to require LPAs to prepare LDPs to an agreed timetable. Do you agree with this proposal, yes or no? So that
this is a questionnaire.
This is, yes, so as I understand, this was the questionnaire that was sent out with the consultation document.
Right.
And the point I make is that what we're looking at in this section are proposals that relate to timetabling and procedure. And that's reinforced by the fact that when people are asked to respond to the proposals, that's the proposal that they're asked to respond to require LPAs to prepare LDPs to an agreed timetable. And it's in that context that we have to look at what's said at paragraph 35, first sentence talks about local planning authorities being required to publish an adopted version of the plan within a fixed period. And I would submit that that's doing what it says. It's dealing with publication of a plan once it's been adopted. It's not, and if it were, different language would be used. It's not suggesting a change to the process so that plans must be adopted upon receipt of the inspector's report. If it were doing that, that proposal would have much greater prominence within the document and would have been expressed differently. And then I have to confess that the last sentence is difficult to reconcile with any provision in the 2004 Act or the 2005 regulations, because it talks about the plan could automatically be adopted after a set period for legal challenge. But the period for legal challenge under the 2004 Act comes after adoption, and that's standard. And so I'm not sure what that is saying. But either way, the key word in that sentence is could. Could. These are proposals which are at quite an early stage. It would be, again, a very convoluted way of finding, of interpreting Section 67 to go from this consultation document, this one paragraph at the end, in the context of timetabling, read that together with paragraph 6 of the explanatory memorandum, and say that that then provided clear and compelling contextual indicators that may in Section 67 in fact means must. And then, my Lord, if I can then deal with the respondent's notice point, which is...
Well, just before you leave
Yes,
this, if I can ask for some help. Yeah. In the 2004 Act, there were separate parts of the statute dealing with England and Wales. Yeah. What was the position before the 2004 Act? Were they dealt with together or separately? And the second question is, under the previous legislation, was there a duty on the part of local authorities, either in England or Wales, to adopt a plan?
So, in terms of the first question, the simple answer is, I'm not 100% sure, but I think under the 1990 Act, there were not separate separate procedures or separate bits of the Act for England and Wales.
Because it might give rise to the question, was this the first time that any duty was imposed on a local authority to adopt? And that might have influenced, according to your submission, the content of a consultation exercise.
Yeah. And then, my Lord, exactly. In terms of the position under the 1990 Act and the UDP and structure plan system, we have looked to see if there's any case law that gives a clear answer on that. And there is no case that answers that, but and you don't have the legislation in front of you. It appears very much that there was a discretion at the end of the process, because the procedure was slightly different, as I understand it, in that there was a local inquiry held where, rather than having an examination, it was a more formalised inquiry and objectors could turn up asking for specific changes to the plan. The report was then published at the end of that, and there was, as I understand it, a discretion on local authorities whether to accept the recommendations made or not.
In other words, perhaps the first time that inspectors' recommendations had a binding effect or a limiting effect was in the 2004 Act?
That might be that. I'm straying slightly out of my comfort zone in terms of...
It might, without going into too much detail, it might be helpful just to know the immediately prior statutory background.
Yes, and if we could potentially have an agreed position, that would help. I'm slightly out of my comfort zone simply because it predates my involvement in this, and also there's no case law or anything that we have looked that gives a clear answer on whether there's a discretion at the end of the process.
Don't venture outside the comfort zone. What I suggest you might consider is looking at this with your colleagues at the short adjournment and see whether some agreed position can be conveyed to the court after that.
Yeah. Yeah. But certainly if the position was that there was a discretion, just going back to the document that we were on, this consultation document, it would be a huge change to go from a discretion to adopt to a mandatory duty to adopt, and one would expect it to have far greater prominence in this document. And then if I can finally deal with the respondent's notice, and this relates to Regulation 25. So the starting point is section 77 of the 2004 Act. And that's at tab 26. Page 66. So it says the Assembly may, by regulations, make provision in connection with the exercise of functions conferred by this part on any person. And then it goes on to refer to what they may in particular make provision on. And B, in terms of ones which appear particularly relevant, B talks about the procedure to be followed in the preparation of local development plans. And I talks about the time at which anything must be done for the purposes of this part. Then go to Regulation 25. That's at tab 30. And it says, the LPA must adopt the LDP within 8 weeks of receipt of the recommendations and reasons given by the person appointed to carry out the examination, unless otherwise agreed in writing by the National Assembly. And the respondents interpret this regulation as effectively setting out 2 requirements. First, the LPA must adopt the LDP on receipt of the recommendations and reasons. And secondly, it must do so within 8 weeks. So the duty to adopt and to do so within 8 weeks. However, there's another interpretation of Regulation 25, which is our interpretation, which is that it's simply dealing with the time period within which any adoption decision must be made. I.e., it's saying if a decision is made to adopt an LDP, that must be made within 8 weeks of receipt of the recommendations. It deals with the timescale for adoption rather than imposing a statutory duty to adopt. And to that extent, it may match up with the first sentence of paragraph 35 in the consultation document that we were talking about publication and the timescale to do that. And in that respect, it's simply giving effect to section 77 2I. So if we go back to that, it's tab 26. Regulations may in particular make provision as to I, the time at which anything must be done for the purposes of the Act. So you have up to 8 weeks to effectively make a decision on whether to adopt or not. And that's all it's doing. And there are 3 reasons why we say that that's actually the most likely interpretation. Firstly, there's an exception in Regulation 25, unless otherwise agreed in writing. Now that's language that is commonly used where permission is being sought to extend a time limit or something to that effect. It would be very surprising if we had a mandatory duty to adopt, not in the primary legislation, but in the regulations, and that was created but could be waived through correspondence with the Welsh Government, rather than through a more formalised process, such as the making of a direction. So that's the first reason why we say the respondent's interpretation doesn't work. But secondly, the inspectors examining the LDP may make recommendations other than adoption. So they could recommend that additional work is required, or they may recommend non-adoption. And in those circumstances, it would clearly be perverse to suggest that Regulation 25 imposes a statutory duty to adopt within 8 weeks. It's saying if you are going to adopt, do so within 8 weeks, or make your decision within 8 weeks. And the third reason is that the procedure in Part 6 governs not just the preparation of LDPs, but also the revision of those plans once adopted. And any changes, any revisions must go through the same Part 6 procedure. We have Regulation 25A, it's the next tab, that deals with the adoption of revisions to an LDP. And it says may adopt a revised LDP with revisions, and basically matches the language and structure of section 67. Now it must be the case that the position on discretion is the same whether you are adopting an LDP or a revision to an LDP. But on the respondent's case, we'd have to read both Regulation 25, which says must adopt, and Regulation 25A, may adopt, as having the same effect. And that, again, simply, we say, doesn't work. Regulation 25 is just setting out a time period for adoption. In any event, even, my lords, if you're not with me on that, Regulation 25 is a provision that can be read either way, and therefore we submit it should be read. Well, the best approach is to construe section 67 without reference to the regulation, and then whatever the outcome of that exercise is likely to shed light on which of the two interpretations of Regulation 25 should prevail, i.e. Regulation 25 should be interpreted consistently, insofar as it's capable of being, with section 67. And I would rely for that on what's said in Benyon, which we have at tab 50, and it's paragraph 3.17, it's page 386. It's the sidelined passage. Delegating legislation to be
So could you give the page reference again, please?
sorry, my lord, it's 386.
Sorry, my fault.
The function of the court, 3 lines down, is to determine the legal meaning of the words used in the delegated legislation. The Enabling Act forms a crucial part of the legislative context in which those words must be construed, and it may well affect their meaning, applying the principles discussed below. So,
And you say there's no reverse principle?
there's no reverse principle, no. So, in terms of the respondent's case, we say, first of all, we do say it's clear and unambiguous that Regulation 25 is simply dealing with timetabling and cannot be read as creating a duty to adopt. Secondly, in any event, it can clearly be read either way. And in that scenario, the approach adopted by the court should be, we say, to read it in a way that's consistent with section 67. So you start with section 67, we then go to Regulation 25 and say, does that change our interpretation of section 67? And only if it's not capable of bearing any other meaning should it be read as imposing a mandatory duty. And that broadly aligns with the approach taken by Mr Justice Eyre. If I just ask you finally to just see how he dealt with Regulation 2025. So it's paragraph 51 of the judgment below. If I could just ask you to read 51 and 52, just so the court can see how this was approached below.
Yes.
My lord, that's all we have to say on the respondent's notice, and I think unless I can help any further, those are my submissions.
There's only that question that was my lord's question left outstanding, to which come back, if you would, after you've conferred with your colleagues.
Just to speed up.
Thank you very much. Yes, Mr. Carter.
May it please your lordships. Like my learned friend, given that this is a matter of statutory construction, the factual background is perhaps not of central relevance, but there is one matter in relation to the factual background that I would just like to highlight, if I may, because the tenor of the appellant's submissions is that the members of the planning authority, the full council, acted in light of some concerns that they had in relation to the planning merits of the inspector's recommendations. But no such indication appears from the terms of either resolution that the members made either in April or in June of last year. The resolution for the reasons for the decision of the 19th of April last year appear, my lords, in the supplementary bundle at tab 1 at page 173. And that is a rather Delphic reason that says that the reason for the decision was to meet the requirements of essentially Regulation 25. So that does not reflect any concern about the planning merits of anything the local planning inspectors, local development planning inspectors reported to the authority. The same is true, but in a different expression of decision, for the resolution of June 2023. That reason appears in the same bundle, my lords, in the same tab at page 213, where the reason for the resolution is all of 4 words: to uphold local democracy. Again, not an engagement with any concern about any planning merits of anything the local planning inspectors said. So I don't accept.
I'm sorry, listen for those words.
Well, page 213,
Yes.
reason for the decision, it's the last entry on the page before,
Yes, I see, I'm sorry.
before the mayor's name.
Look, I was looking in the wrong place, thank you.
And so I do not accept that the court can infer that the reason for the member's decision was anything to do with detailed concerns about the planning merits of anything the local planning inspectors had reported. That's the only thing I want to say about the factual background, my lords.
You took us to page 173, and that sets out the resolution. The minutes on the previous page indicate some concerns which individual members have. The case law makes it clear there's always difficulty in deciding what was the basis for a resolution as opposed to the views of individual members.
Lord, yes.
But to be in fairness, there are some concerns expressed two-thirds of the way down the page.
There were, my lords, and if I don't intend to take your lordships through it, but we've got 2 long transcripts for both meetings. I accept that individual members did express concerns about various aspects of the plan: provision of a site for gypsies and travellers, the treatment of affordable housing, some individual housing allocations. But those do not find their way into the resolution. And as your lordship has said, those are just the views of individual councillors. I would urge caution upon acting upon those for two reasons. Firstly, the timing of them. Who knows whether what that member said was actually the basis upon which they formed their decision later on. And the second reason would be the fact that they are individual members is, in my submission, particularly important here because the decision maker was not a small-ish committee of the authority where perhaps an individual member's views have more proportionate weight. This was a meeting of the full council on both occasions, as it had to be.
Yes. Right.
My Lord, by way of an overview, the tenor of my submissions is going to be that the appellant's approach places too much emphasis on one word in one section of the Act and fails to pay sufficient attention to the overall statutory architecture, if I can call it that, the context in which Section 67 sits. And if necessary, the first respondent would rely on the respondent's notice in addition. But Lord Mopson, my principal point is that Section 67, when interpreted in context, does impose an obligation to adopt the local development plan. And there are three planks to that argument. Firstly, and the main one, is the statutory context for Section 67. The second is the assistance which can be derived from the explanatory notes to the 2004 Act, although I accept that that is secondary material and it obviously can't be used to construe the Act in a way that is contrary to what the words mean in their context. And thirdly, the use of Regulation 25 as an aid to interpreting Section 67, should that be thought necessary. My Lord, it's safe to say that the first limb of my argument is going to require the most time to explain of the three. Turning to the statutory scheme, it is, in my submission, fundamental to bear in mind that planning is a devolved function, and there is no reason whatever why the law in Wales should be the same as the law in England. And moreover, as your Lordships have seen already, and as I shall seek to emphasise during the course of my submissions, there have been conscious decisions to move the law in Wales in a different direction from the law in England. And I make that point for two reasons. Firstly, it's therefore not of great assistance to understand the law in England, to understand the law in Wales. And secondly, the way in which the law in Wales has moved shows a greater share of the power for the second respondent as compared to the local planning authority, and I'll seek to make that submission good in a little while. There are some important matters of the statutory scheme which inform my submissions, which have not yet been drawn to your Lordship's attention. So if I may, I would just like to deal with some aspects of the statutory scheme. My starting point is section 38, subsection 4 of the Planning and Compulsory Purchase Act 2004, which is at tab 9 of the authorities bundle, page 32.
Yes.
Because in Wales, the statutory development plan has three tiers. It has a national one, a strategic one on a regional basis, and I'm told that there are as yet no strategic development plans for anywhere in Wales. Those documents are still being worked upon. And then thirdly, there is the local development plan for the authority's area. And so the starting point is that the national policy is not just a matter to which the planning authority has to have regard, like an English authority does with the NPPF. It's an actual component of the development plan, and as the Lord Justice Holgate observed during the course of argument a little while ago, there is a duty for the local development plan to be in general conformity with the national development framework rather than just having regard to it. So the national policy has a much greater role to play in the development plan in Wales than it does in England, and has a greater status.
Where is the requirement for general conformity?
My Lord, that will be, I think, in section 60. No, it won't. It will be in section 62.
Right.
Tab 16, page 48, my Lord, section 62, subsection 3A. The plan, that's the local development plan, must be in general conformity with, firstly, the National Development Framework for Wales, and then any strategic development plan.
Thank you.
And my Lord, tab 10 of the same bundle, page 35, section 60 regulates the process for preparing the National Development Framework, and that is a mandatory requirement. So the second respondent has taken on the onus of preparing that document and making it a component of the development plan. The current National Development Framework for Wales is a document called Future Wales, the National Plan 2040, which your Lordships have at Supplementary Bundle tab 3, page 322. It starts on page 322. I seek to draw some assistance from the short point on page 325 of the National Development Framework for Wales. The right-hand column at the top. Strategic and local development plans are required to be in conformity with Future Wales and must be kept up to date to ensure that they and Future Wales work together effectively. So there is an expression in the Statutory Development Plan of not only keeping the development plans up to date, but making sure that that is done so that the three components of the development plan work in lockstep rather than getting out of sync.
I'm so sorry to be behind. You were reading from?
Page 325, my Lord.
Yes.
It's the one that's got the schematic of Wales with
I've got it.
a wheel around it, and then the right-hand column above that, my Lord, is where I was quoting from.
I see, yes. I've got it. Thank you very much.
And then section 62 of the 2004 Act, my Lord, which is at tab 16 of the authorities bundle.
Yes.
Subsection 1 imposes an obligation on the local planning authority to prepare a local development plan. There is a similar obligation on local planning authorities in England to do so. But there is an important point of distinction in my submission in section 62. Because if your Lordships look at, please, at page 50 of this bundle, my learned friend took your Lordships to subsection 8, which notes the need for a resolution for adoption. But there are also important other provisions. The subsection 3B on 3 capital B on page 48 says that the plan must specify the period for which it is to have effect, and then the point which I submit is of some significance is the consequence of that. The very last subsection of section 62, my Lord, subsection 9, a plan ceases to be a local development plan on the expiry of the period specified under subsection 3B. That's distinct from England. In England there is no provision equivalent to that. So in Wales, a local development plan has a lifespan, and when that lifespan, which has to be stated on its face, expires, the document's status as a local development plan ends. That's not the position in England. And that, in my submission, is another material indication of the way in which the two legislative systems have moved apart. And it does have some bearing upon the question that your Lordships have to grapple with in this appeal.
Thank you. Does there exist the concept of a plan being out of date in either legislative or more likely policy terms? In other words, not, as it were, time expired, which is subsection 9, but actually by reason of supervening events, changes of policy, changes of circumstances.
Certainly yes, my Lord. Certainly yes.
Is that in Future Wales?
I don't know, I'm afraid, my Lord, off the top of my head. Certainly there is a concept, that concept applies in England plainly. Because
I mean, sometimes it's said, I'm not saying it's this case at all, of course, sometimes it's said a plan was out of date even on the point of its adoption. I'm not saying that's this case, of course.
I'm afraid I don't know what the answer to that particular point is in the context of the Welsh system.
But it would be interesting to chase down the source of the concept in Wales that a plan can be out of date even though it's not yet time expired.
Well, yes, Lord, I'm grateful to learn from Mr Corner, King's Counsel, because the paragraph in Future Wales that I took the court to a moment ago, which referred to the need to keep plans up to date,
Yes.
there must be an obverse to that, that if they are out of date, some adverse consequence flows. I don't know whether that means that is intended to connote some reference to reduced weight to the policy, or that is just an undesirable situation to be in because the plan doesn't keep track with real-world events. But there is clearly a reference to the need to keep plans up to date, the obverse of that being something undesirable follows if they're not.
Thank you very much.
Can I just ask you about the statute? You've taken us to section 62, subsection 3b and subsection 9.
But oh yes.
Does the statute set out any consequences if a plan ceases to have effect because its time of expired?
No, my lord. But the consequences would flow from its ceasing to be part of the development plan. So the statutory presumption in section 38(6) would no longer apply to it. It would just become essentially, I suppose, it would become a material consideration in decision making rather than part of the statutory starting point.
But it doesn't give rise to any obligations specifically because of what we see in subsection 9?
My lord, no, not as far as I'm aware. The statute, in my submission, works by imposing the obligation to have the local development plan, and then it's required to be kept up to date. The hope being that the plan is reviewed or replaced prior to its expiry date at the end of the plan period.
But you're not contending that the effect of subsection 9 of section 62 is that on the day after the plan has ceased to be a local development plan, it is for that reason an immaterial
no, certainly not.
consideration. No, that's not what you're submitting.
Certainly not. No, I would only go so far as to say it loses its status as part of the development plan.
Understood.
Lord, there's nothing in relation to section 63 that I need to address the court about. In relation to section 64, there are a few matters to note about section 64 in my submission. The first is in subsection 2, the authority must not submit the plan for examination unless they've complied with any relevant requirements contained in regulations, and that they think the plan is ready for independent examination. And we are told what that means, and this next point hopefully deals with an observation that Lord Justice Holgate made earlier on. The examination process is to test the plan for soundness, because we can see that in subsection 5 of section 64. There is an obligation in subsection 5, paragraph A, to test whether, in shorthand, it meets relevant legal requirements. And then the second obligation is to test whether the plan is sound. So there is an element of soundness testing for the local development plan.
I think the question related to whether or not there's anything in the statute which prevents adoption of a plan if an inspector says this is not sound.
Only
because in England I think there is, isn't there?
My lord, yes. In my submission, what would if an inspector thought that the plan was not sound, he or she would recommend it's not adopted.
Or
withdrawn.
He or she might make recommendations for modification.
Yes.
Without being called upon by the local authority to go through a main modifications procedure.
Yeah, matters arising changes that I think they referred to.
Yes,
you're right. They certainly were referred to as that in this process. Lord, yes. Section 65 is your lordships have been taken to that already. The Assembly's powers of intervention. I accept that that is a power that applies at any time prior to adoption, because that is what subsection 4 says so far as directing the plan to be submitted to it for approval is concerned. But in my submission it is notable and instructive that subsection 5 firstly prohibits the authority from taking any step in connection with the adoption of the plan until the Assembly has decided what it wants to do. But then paragraphs B and C say what is to happen. Firstly, if the direction is given before the authority have submitted the plan for examination, then the Assembly must hold the examination and the relevant provisions are applied to that process. And then C, if the direction is given after the authority has submitted, then the person appointed must make his recommendations to the Assembly, now the Welsh Ministers. What is missing from section 65 is any procedural prescription as to what should happen or how the examiner's report is to be treated if the Welsh Ministers exercise this power after the inspectors have reported but before a decision on adoption is made. And in my submission, the absence of any such provision, even if it's only to say something like the inspector's report shall be treated as having been made to the Assembly rather than the local planning authority, the absence of any such provision is an indication that this scheme of legislation works on the basis that no provision had to be made because the authority is under a duty to adopt the plan at that stage. So I do accept that the power exists throughout the process up to adoption, but I do submit that the absence of anything, any procedural indication as to what should happen post-report but prior to adoption does support the all the respondents' submissions as to the way in which section 67 operates when seen in context.
So the absence of anything, you say, supports an obligation to adopt, but it's in a situation where the Minister, post-publication of the Inspector's report, has given a section 65(4) direction. And where he does that, aren't we told in the statute that the local authority can't adopt? It's now in the hands of the Ministers.
Yes, we are. Yes, we are, my Lord.
So why does the statute need to say anything?
Because it would leave unsaid what is the approach to be taken to the inspector's report, because the legislation works on the basis that the report is directed to the authority. It would leave unspecified how the Assembly is to treat the inspector's report on the local plan examination, local development plan examination. And because, perhaps one other thing to note about section 65 is that in distinction to section 71, as we shall see, I shall demonstrate in a moment, section 65 is a power that applies where the authority, where the Assembly, as was, Welsh Ministers now, there are no particular entry requirements in relation to how this power is exercised. It doesn't have to be satisfied. It doesn't have to be dissatisfied with anything that a particular body has done or has not done. So the Welsh Ministers could be unhappy with the way the local planning authority is conducting plan preparation, or it could be unhappy with the way the inspectors have conducted the local plan examination, or it could be unhappy for some other reason, such as it's just promulgated a significant change in national policy that it wants to be taken into account. Whereas in section 71, the entry requirement is that the second respondent has to be dissatisfied with the way the local planning authority are conducting the plan preparation process. That's subsection 1 of section 71. And section 65 contains not just powers to call in, as my learned friend quite rightly characterised it. There's also the power in subsection 1 and 2 to direct modification. So a short circuit, just make the plan say something different, and then the local planning authority have to comply with that direction.
Do you have any submissions about subsection 9 of section 65? Do they have any relevance to the interpretation of section 67?
Only, my lord, that the second respondent has a relatively free hand in relation to how it responds to a plan that is submitted to it. The words used in subsection 9, paragraph A, are wide enough to allow it to take any action it sees fit in response to a plan that has been submitted to it. Well, then we turn to what in my submission is the most important indication of the divergence of the powers in England and Wales, which is section 66. And the starting point, perhaps, is to look at section 66 as originally enacted, which is Authorities Bundle tab 20, page 59. Subsection 1 set up a power to withdraw, and then subsection 2 constrained it in the circumstances that the plan had been submitted for examination, and essentially prohibited withdrawal unless the person examining the plan directs that, or the second respondent directs that the plan must be withdrawn. The 2015 amendments inserted a new version of section 66 and section 66A, and whereas section 66, the original section 66, was a power for the local planning authority, the new version of section 66 is a power conferred upon the second respondent, which is a power for them to direct withdrawal, and is a power that exists at any time prior to adoption, with an obligation to give reasons, and then the authority must withdraw in accordance with the direction. Section 66A replicates the former restrictions on withdrawal in section 66A, subsection 4. That provision corresponds to the old version of section 66. But it does, in my submission, two main new things. The first new thing it does is to restrict the ability to withdraw a plan prior to submission, as my learned friend, the appellant, took the court through. The reasons for that were that the second respondent was concerned that plans were being withdrawn for what it regarded as poor reasons, and so the provisions in section 66A prohibit withdrawal prior to submission unless notice is given to the second respondent, giving the second respondent chance to intervene if it sees fit, without the plan being withdrawn, without all the documents disappearing from the website and so on, so the problem that my learned friend rightly identified had existed before. So that's the first new thing that section 66A did. And then the second thing that the provision did is connected to that, which is to empower the second respondent to make directions to require the local planning authority to give them information during the period where they are considering whether to intervene prior to allowing withdrawal or intervening in the process themselves.
I thought there was another addition as well in section 66, capital A, subsection 3. That I may have missed.
Yes,
That's a power. So it removes the power to withdraw once a section 65(4) direction's been given.
Yes. Obviously at whatever stage.
There are three things, aren't there? 3, 4 and 5.
Yes.
May not, the formulation differs actually, but it says may not withdraw in subsection 3, then may withdraw only if in 4 and 5.
Lord, yes.
But it comes to the same thing, presumably.
Lord, yes. there is perhaps one other thing as well that section 66A does, which is that the restrictions on withdrawal only apply if the authority has taken steps that are required by regulations. That's what subsection 6B says. If the draft plan is at an even earlier stage than that, there is no requirement to give notice, presumably because the plan is at a sufficiently embryonic stage that Welsh ministers didn't wish to be concerned about intervening at that early stage. But there is no restriction on there's no restriction on withdrawal if no formal step under regulations has been taken. So the short point about section 66 and 66A as replaced was to restrict powers of withdrawal compared to how they had formerly been, and to give the second respondent opportunity to intervene if withdrawal is proposed after the taking of steps prescribed by regulations. And in my submission, section 66A is another illustration of the Welsh Government being given more interventionist powers than the situation in England would be.
Just explain, if you would, for my benefit, if I may, how you say the interpretation, section 66A affects the interpretation of section 67.
Because if there are substantial restrictions upon the ability to withdraw a plan, those restrictions are effectively undermined if a local planning authority has a free hand at the end of the process, whether it is to adopt a plan or not.
You're not saying that, your point is that section 67 has meant the same thing throughout, isn't it? Or do you say, are you saying it's changed what it means?
My submission has to be that section 67 has meant the same throughout, because I'm relying upon the 2005 regulation as a means of interpreting it.
So you're relying on a subsequent amendment.
It's
How do you say that?
what
weight can be attached to a subsequent amendment in interpreting the intention of Parliament of the original statute?
Because, my lord, the situation is that when my clients came to consider the legal position, they needed to consider what the legal position was at the date the authority was confronted with the question of adopting the plan, and that's the structure of the 2004 Act as it existed at that date.
Thank you.
And to deal with the point to grapple with the point about England, I'm not instructed to make any submissions about what the law in England is, but in my submission, what matters is what the law in England is now. And given the way that section 22 was amended, and your lordships have been taken through that, originally a restriction on withdrawal which was immaterially different from the structure of the old section 66. I say immaterially different because there's the distinction between local development documents and local plans to grapple with in England that doesn't apply in Wales, but the substance of it is the same. But however the two provisions started, they have diverged significantly since, because the current version of section 22, which is at tab 7 of the authority bundle, page 28, section 22 clearly gives a very free hand to the local planning authority to withdraw any local development document at any stage prior to adoption. And so, whatever the statutory history, as of now, the law in England is very different from the law in Wales as regards the interplay between withdrawal powers and adoption.
So you're saying, are you, that is it your Mr. Parkinson said it wasn't clear how the respondents were putting their position on the change. You're saying that that in Wales it's always been mandatory mandatory, and in England it's changed.
Given that I'm relying in part on Regulation 25 to interpret the Act, that must be the logic of my position. Yes.
So the position has changed. Your submission has the effect of requiring the law in England to have changed.
It may well have done, but I'm not making any submissions about what the law in England is,
No,
save for how it is now.
No, I appreciate that. You've said that very clearly. But it's my Lord's question goes to the consequence of your argument, which I think we're entitled to ask you about.
Yes, I mean there's no, in my submission, there's no reason in legal principle why the same word may have different meanings in different parts of the same act when the overall context is looked at.
So, right. So may means different things in England from what it means in Wales, under your understanding of the...
That may well be the consequence of my submissions, yes.
But we would need to be clear about which parts of the same statute enacted by the same Parliament you say have different meanings in the two different jurisdictions. I'm not following at the moment. I'm sure it's my fault.
Well, Lord, I'm only going so far as to say that the word may in section 67 imposes an obligation to adopt. I'm not instructed to go any further than that.
But the trouble is you rightly invite the court to read the statute as a whole, but the statute as a whole is made up of its component parts.
It is, well, yes.
And if you are going to place reliance as part of the statute scheme upon provisions which find their equivalent in England, doesn't this court have to be careful about the implications of your argument for England?
My Lord, yes, and there are not necessarily any implications, because my submissions depend upon not just the words of section 67 but the interplay of part 6, particularly the withdrawal provisions as they interplay with the adoption provisions.
Exactly, and we're looking at... Sorry.
And yet the provisions in England in part 2 that interplay is very different, because the withdrawal powers are essentially unrestricted in England.
Yes,
so
but not originally.
Not originally, no. But now they are.
Does it follow that, given that as you very elegantly put it a moment ago, originally they were immaterially different from the provisions in Wales, does it mean that really your argument rests on those provisions in Wales which are different,
Yes.
which have been introduced?
It's a yes, in distinction from what has happened in England in the meantime. The law in Wales has moved to tighten and restrict, or to maintain some restrictions on withdrawal and impose new restrictions on withdrawal. The law in England has moved in the completely opposite direction to make the process of withdrawal much easier for the local planning authority than it ever was before.
Right. Very well, thank you. Is this a convenient moment
Yes,
to break? Thank you, Mr. Carter. Could we just review time overall? I just want to get some idea of what the afternoon looks like, and whether we're going to be able to complete argument today.
Lord, I would estimate I'm a little over halfway through.
Mm-hmm. I don't think I made a note of when you started.
I think it was about 12:15, my Lord.
If it was. So you've got another 3/4 of an hour or so, something like that.
And I will edit my notes over the...
I just want to get some idea. Then Mr. Corner, Miss Ellis.
I would have thought, my lord, I'd be about an hour.
I would imagine, my lord, that I'll be adopting the submissions of my learned friends. and sweeping up miscellaneous points.
Yes.
I think at the moment I'm the one with the best recollection of how things were before 2004 as well, which we'll try and get agreed over the adjournment. But that may need to be presented to the court in some form.
Yes, no, thank you very much. Well, there is then a prospect, at least, of completing it today, without any pressure at all on anyone. I just wanted to get an idea, but that does look as if it's a prospect. Good, thank you. Well then, we'll come back at 5 minutes past 2. Thank you. 2:05.
Court rise at